Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. Happy Monday. Happy Monday, my friends. Today's Monday, December 29th, 2025. And the year is almost over. Wow. 2 more days left in 2025. Where did that go? I don't know. I'm a little cranky today. I was up until like 5 o'clock in the morning. I couldn't fall asleep. Never happens to me. I'm always a sleeper. And so the show is supposed to be at 10. If you thought it was supposed to be at 10, I apologize. I moved it to 11 because cranky as I am right now, I would be 10 times crankier if I did this at 10 a.m. We're going back to Oklahoma today. We're going back to Oklahoma for the first show of the day. And then at 2 p.m., we're going to start trial prep on Sarah Grace Patrick. That trial is supposed to start next Monday in Carroll County, Georgia. Carroll County, right? Carrollton is the town that it happened in. Carroll is the county. We did a show yesterday for about 2 hours, and we talked about all the cases we talked about last year and all the cases that we're going to talk about this year and what you guys are interested in. And so I'm so happy to hear about what you're interested in. And I went to I don't know what it is, cranky. It's Monday. Low tolerance for the BS. I don't know. Went to a movie last night with my kids. They like Timothy Chalamet, and so they wanted to see this movie called Marty Supreme. Did anybody see it? Anybody see Marty Supreme over the weekend? It's about a ping pong champion in like the 1950s. This may be an unpopular opinion, but it's 2.5 hours of my life that I will never get back. Sometimes I wonder how some of these movies even get made. Gwyneth Paltrow was in it. Timothy Chalamet was in it. Fran Drescher was in it for about 2 seconds. And when the best part of the movie was Kevin O'Leary from Shark Tank as an actor, you know something's up. Kevin O'Leary from Mr. Wonderful. Mr. Wonderful is in this Josh Safdie movie, playing the, arch nemesis of Timothy Chalamet. And it was literally 2.5 hours of my life I'm never going to get back. I'm not discouraging you from going to see it, but I cannot in any way recommend it. None of the characters were likable. None of the plot points made sense. There was all these holes in the plot that were never tied up together. Did anybody see it? Am I alone here? Am I alone? Let me know if you saw it, because maybe I'm alone, because when I came home and rushed to read the reviews on this thing, some people are raving about it. It does, Jeff, have a little bit to do with ping pong, but not so much. And ping pong's not an exciting sport to watch on film. I don't know. Mr. Wonderful. When did he want to be an actor? I had no idea. I had no idea. I don't want to spoil it for you by giving you away the ridiculous plot points, but it's yeah, would not recommend. Just can't do it. Timothy Chalamet, I don't know how long it's going to be out. I don't know how long it's going to be out there, but save your money. I mean, the set design was amazing. It was New York City, gritty New York City in the 1950s. Kind of cool. You know, wardrobe on point, set design on point, cinematography on point, but the rest of it, don't do it. I mean, do it if you want, and then come back and complain to me so that you guys usually like the things that I like for the most part, right? Like a lot of people are watching Landman now. No, Mr. Wonderful's role was like supporting actor. Like he had a big part in this film. And he wasn't terrible. But I don't know how he got the job. Did he all of a sudden decide he wants to be an actor? I have no idea. Don't know. All right. Let's get out there to Oklahoma and talk about Jesse Stillwater. I mean, Jesse Stillwater. Jesse MACK Butler in Stillwater, Oklahoma. I'm going to get it one of these days. For those of you not familiar with this case, Jesse MACK Butler is I guess he was 17 when these crimes were committed. Senior in high school at Stillwater High. These assaults happened in, I believe it was in 2024, September. He pled guilty to the grape of two 17-year-old girls that he was dating from the high school. Both of them were graped. One of them was violently strangled and was 30 seconds away from death, according to her doctor. She has recently undergone surgery on her neck because of this strangulation. One of the girls' families got a restraining order against him. We're going to go over the federal lawsuit today because you will be horrified to find out, or maybe you won't, that the Stillwater Public School District did nothing to protect his victim and everything to protect this disgusting POS kid whose father used to be, I think, the athletic director for OSU football and is now the athletic director for Stillwater Public Schools. And so what happened, this article from News 9 says that Jesse Butler was convicted of graping. I don't think there was a trial. I think he pled guilty. He also filmed these events on his phone because that's the kind of guy he is. He was initially facing a 78-year sentence on multiple charges related to grape, which is what we have to say on YouTube. So just please be mindful of what you write in the chat. But he was granted youthful offender status, which relieved him of serving any jail time at all. He was sentenced to something like court-mandated community service for a year and counseling for a year. And I think 1 year's probation. And if he completes that satisfactorily, I don't even think he's going to have a record. And so this started to get some traction about, I don't know, a couple months ago. And because the victims were so horrified by this and so outraged, and the town is outraged, and rightfully so. One of the attorneys of one of the victims in Jesse Butler's case filed a motion to enforce the victim's rights under Marsy's Law. So Marsy's Law was passed in 2018. It's MARSY. And it grants, it says Marsy's Law was passed in 2018 and grants to victims grants rights to victims, making sure that they're protected by law, treated with dignity, and notified of proceedings such as parole or sentencing. The attorney for one of the victims has now filed a motion in the criminal court saying that these rights were not granted to the victim, that she was not advised of any of this. She's not on board with this. And the victim is seeking a new hearing and prison time for Butler. In a statement, Marcy's Law for Oklahoma said, quote, Marcy's Law has provided Oklahoma crime victims with enforceable constitutional rights since 2019. This includes the right to confer with the prosecution and to be heard at any proceeding involving release, plea, or sentencing. Though these rights do not guarantee the crime victim an outcome, they do offer the victim a voice in the process. While we cannot comment on any specific case, it is a serious issue if Marcy's Law rights are not upheld, including those instances where they have been previously violated. This is an article that was just published on December 15th, 2025. And in response to that, the district attorney's office put out the following statement. And this is Payne County, Payne County in Oklahoma. Let's take a look at that statement. Is he a privileged class in town? In his town, Kim says, yeah, either it's because, in my opinion, he's a guy or because his father used to work for the OSU football team. Thank you to Strange Credulity for gifting 5 memberships. You are so very generous so early in the morning. And a lot of this Strange Credulity, and we are outraged. If you haven't heard about this, you're likely going to be outraged too. And it is my firm belief, having represented many, many, many victims of not only clergy SA, but all kinds of SA and DV, that guys like this just might not be able to be rehabilitated. Thank you for gifting 5 memberships. I appreciate you so much. Let's take a look at Lauren Austin Thomas's statement. She's the district attorney for Payne County, Oklahoma, and here's what she has to say about it in response to the public outrage. In response to a number of requests for comment regarding the state of Oklahoma's prosecution of Jesse Butler, District Attorney Laura Austin Thomas has provided the following statement. The District Attorney's Office carefully evaluates every case submitted for prosecution to determine the strengths and weaknesses of the available evidence and potential defenses. The charges in this matter allege conduct by a 16-year-old male. Oh, it's even worse. He was only 16 at the time. Directed at similarly aged young women. You know what blows my mind so much more than so many of the other things that blow my mind in the cases that we begin to cover is that it is female judges and female district attorneys saying shit like this. Sorry, I don't even curse ever, but this is what I call, this is when I got to get off the button. Here's the button. Most crimes committed by persons under 18 must be filed in juvenile court where proceedings are confidential and have no potential for incarceration in the adult system. A significant number of more serious crimes provide the option of filing as a youthful offender. As a youthful offender, the accused has an opportunity for rehabilitation, but can be transitioned to adult status and adult punishment if those efforts fail. Oh, so if he doesn't show up for his counseling to rehabilitate him from being a woman beater, Maybe then he'll face some consequences or ramifications for his behavior. Maybe then. You're going to see from the lawsuit that I'm going to read to you that it seems that his parents knew about it and may have been in the house when it was happening. A much more limited number of crimes allow the state to file the charges in adult court from the beginning. The youthful offender sentence imposed against Jesse Butler requires him to complete his rehabilitation plan successfully, including an aggressive schedule of therapy with a specialist in sex offender treatment. And should he fail, he faces reclassification as an adult and a sentence of 10 years in prison. But we're going to give him a chance to rehabilitate himself. Years of experience tell us that juries often struggle with convicting defendants based upon delayed reports of SA between people in ongoing consensual dating relationships, and the trial process can be very traumatic for victims. Oh, I'm sorry. What? Did you ask these girls if they wanted to testify against him? Because they do. Because maybe, just maybe, they want to prevent this from happening to any other girls in the future. This kid was 16 at the time. Wow. Nonetheless, after consultation with the victims and their families, we chose to file this matter and to file it in adult court rather than juvenile court in order to bring the serious behavior at issue into the public eye and with hopes of avoiding a later reclassification of the case to juvenile status. Please don't herniate a disc patting yourself on the back here, ma'am. In accordance with Oklahoma law, this filing decision then afforded the defendant the opportunity to seek certification of his charges to youthful offender or juvenile status. We explained that youthful offender was the most likely final outcome, particularly because the 2 counts of attempted grape were the only alleged crimes among the 11 charged that even qualified the case for filing in adult court. And additionally, because existing law strongly favors providing offenders under 18 an opportunity for rehabilitation. Yeah. Happy New Year, Amanda. Happy New Year to you. Thanks for hanging out for 10 months. Well, hey, victims, we told you that this would kind of be what the judge did based on what his status as a football family. And football is a really, really big deal in Oklahoma. Not that it's not a big deal anywhere else, but it's a really big deal. And these aren't attempted grapes, actually. These girls actually were raped. One of them was almost murdered. Why did you not charge him with attempted murder? I'm sorry. How many other victims are there? How many other victims are there that will never come forward because of this? The parents are being sued. I'm going to read that to you. Somebody said parents should be charged. They are being sued, and we're going to read that federal lawsuit in a moment. But it seems a lot of you aren't unafraid of this, aren't aware of this case. My words will come to me eventually. Hold, please. So parents in Oklahoma, lock up your daughters. The ultimate resolution of the case reached without either victim having to testify or face cross-examination in a contested proceeding, including the accused agreeing not to challenge on any of the allegations and to be sentenced to the outcome described above, including the potential for imprisonment in the penitentiary. Bravo. Bravo. District Attorney of Payne County, Oklahoma, Laura Austin Thomas. We let him plead guilty so that the victims wouldn't have to go through the trauma of a trial. Are you effing kidding me? You ever think they might want to get their power back by testifying against this monster and putting him in jail or prison for a hella long time because he doesn't deserve to be roaming free? He pled guilty. Okay? There's no question about what happened here. Not a question at all. Parents, lock up your daughters. Hold on one second, because if you haven't seen the body cam footage of this kid being arrested, you might want to see it. Oh, please, will I find it for you? I'm outraged by this. Here's the body cam footage of his arrest. This one's only about a minute long. I think there's a longer version, but I need to find it. So hang on one second. Does anybody know anything about this district attorney? Because I don't. I didn't do the deep dive yet. Seems like they're not going to do anything about it. Here we go. Let's see if there's any captions on this. Guess not. Okay, here we go. It's at the
So we're here. We're obviously going to place you under arrest.
Let me just read what it says there. This is posted on Facebook by somebody who says, I'll tell you who the poster is after. The following footage shows the arrest of Jesse MACK Butler by Stillwater Police Department. It's not the arrest that stands out. It's his mother's response. Where does accountability begin? With the offender or the home that shaped him? Okay, come to your screen if you can. I'm going to just see if I can make this a little bit bigger for you. This is posted.
So we're here. We're obviously going to place you under arrest. There's a warrant for your arrest. We're going to take you to the jail. I told your mom that she can contact a bondsman, and you shouldn't be there very long. But there just is a process for paperwork and stuff. But right now you do have to come with us, and I do have to put you in handcuffs. So turn around for me. You have to put in handcuffs. You know, I'll get you out for me. All right, stay silent. Rick knows about this. Candy's on this. Dad's on his way. We're coming to get you, okay? Stay strong, okay? Say your prayers. Okay, so we
say your prayers. Guess what? Jesus is not going to save him now, Mama.
Well, he's going to go right to the city of Stillwater jail. Experience for a child.
What an awful experience for a child, the mom says. What an awful experience for you know what's an awful experience? Being raped by a 16-year-old guy who strangles you for fun, films it, and you almost have your neck broken and you need surgery and you almost die. That's traumatic.
I'm wearing something that every woman in this country needs. You can't see it.
I'm sorry, what? What a tragic thing for Mrs. Butler's son to have to go through, isn't it? I mean, I feel really sad for him. I don't even know where to go with this, you guys. I don't even know where to go with this because I'm so outraged by it. No accountability. Right. The girl he attacked is mostly deaf. That is true too. Where do you think this guy learned this behavior? 16-year-old boys just don't start graping girls and choking them unless they've learned that behavior, observed that behavior somewhere else, maybe, sometimes, maybe. All right. So here's a lawsuit that was just filed on the 22nd of December because we're right on top of it. I don't know what's going to happen with that motion, but we'll keep on top of that as well. This is the motion filed by the family of one of the victims. Her name is protected because she's a minor. Her parents have chosen to put their names on the lawsuit, and so it's public, not doxing anyone. Here is the lawsuit. And this is filed in the United States District Court for the Western District of Oklahoma. There are a lot of defendants other than just Jesse Butler. The title of the case is Amber Selvey and Tyler Selvey, and on behalf of their minor child, LS, against Independent School District number 16 of Payne County, state of Oklahoma, aka the Stillwater Public School District. 2, the city of Stillwater. 3, Jesse Butler, an individual. 4, Jackie Butler, an individual. MACK Butler, in his individual and official capacity. So he's being sued not only as Jesse's father, but as the athletic director at Stillwater Public Schools. Paul Blankenship, in his individual and official capacity. And Walter Howell, in his individual and official capacity. One of them is the principal of the school, and the other is the school resource officer, who is law enforcement. And here's the complaint. Plaintiffs Amber Selvey, Tyler Selvey, and LS for their claims for relief against defendants Independent School District number 16 of Payne County, state of Oklahoma, aka Stillwater Public School District, aka Stillwater Independent School District number 16, city of Stillwater, Jesse Butler, Jackie Butler, MACK Butler, Paul Blankenship, and Walter Howell, state as follows. Parties, jurisdiction, and venue. And they go on to say where each party lives, the Payne County. And at all relevant times, the minor daughter was a student attending Stillwater High School in the district. The plaintiff, the minor plaintiff, the female, is a deaf/hard of hearing individual and has an individualized education plan, IEP, to accommodate her disability. Defendant, Independent School District number 16, aka Stillwater Public School District, is a public school district established under the laws of Oklahoma, located in Stillwater, Oklahoma, and it is an educational institution as provided under Title IX. Defendant, City of Stillwater, is a municipality incorporated under the laws of Oklahoma. Upon information and belief, the Stillwater Police Department is a municipal department under the control of the City of Stillwater. Jesse Butler is a resident of Payne County, Oklahoma, and was a resident there during the incidents which give rise to the claims for relief herein. At all relevant times, defendant Jesse Butler was a student attending Stillwater Public High School. Defendant Jackie Butler, Jesse Butler's mother, is a resident of Payne County. Defendant MACK Butler, Jesse Butler's father, is a resident of Payne County, Oklahoma, and was a resident there during the incidents which give rise to the claims for relief set forth herein. At all relevant times, MACK Butler was employed by defendant's school district as the assistant athletic director for Stillwater Public Schools. Defendant Paul Blankenship, hereinafter referred to as SRO Blankenship, School Resource Officer Blankenship, was employed as a school resource officer for Stillwater High School by defendant's school district and defendant's city. Upon information and belief, defendant Walter Howell is a resident of Payne County. He was employed by defendant school district as the principal of Stillwater High School. Jurisdiction is proper in this court pursuant to 28 U.S.C. 1331 for all claims arising under federal law and 28 U.S.C. 1367 for all state law claims arising from the same facts. Venue is proper, as in everything happened in the Western District of Oklahoma, and that's where the defendants reside. As required by Oklahoma statute, the Oklahoma Governmental Tort Claims Act, plaintiffs submitted a tort claim notice on September 8th of 2025, which was received by defendant school district on September 10th, 2025, and the defendant city on September 11th, 2025. 90 days passed with no action on the claim by defendant as to acceptance or denial of the claim, which claim was deemed denied on December 10th, 2025. The 180-day filing period expires on June 7th, 2026, and this suit is commenced within that 180-day period. So this is very similar to New York law in that when you are suing a municipality, you need to serve a notice of claim within 90 days of the incident. There are some exceptions if you're a minor under the law, tolling provisions for statutes of limitations. But after you serve the notice of claim, the municipality has 90 days to respond. And here in New York, every time you file a notice of claim, the municipality or the school district will serve you with a notice so that your client's 50H hearing can be held, which is a mini deposition where they can take your client into a conference room under oath and have them give testimony about the claim and learn about the claim. They never did that in this situation. They just kind of ignored it. And so if 90 days pass and they don't do anything, you can then file your lawsuit, which is what they did here in federal court. Plaintiff LS, that's the minor female, will attain the age of majority in January of 2026. Thus, all claims are timely filed within the relevant statute of limitations. So I will just tell you about New York because I'm not 100% certain about Oklahoma. But in New York, the statute of limitations on a claim does not begin to run until you reach the age of 18. And depending on who you're suing, it could be a year and 90 days to file a claim if it's a municipality. It could be 3 years if it's a negligence claim. It could be a 1-year statute of limitation from the age of 18 if it's an assault claim, and so forth. Hold, please. And here are facts common to all causes of action. So buckle up your seatbelts, because if you were not already outraged, trust me when I tell you it's coming. Trigger warning. Upon information and belief, Jesse Butler has a demonstrable pattern of disturbing, violent, aggressive behavior. One example of this disturbing behavior is that he would repeatedly slam his head against the wall in the baseball clubhouse when angry or frustrated. Yeah, I guess he was a baseball player. Yes, he did plead guilty. He pled guilty, and the district attorney's statement, which we read a little bit earlier, in case you missed it, go back and rewind for it later. She said he pled guilty as a favor to the victims, so they wouldn't have to go through the trauma of a trial and testifying against him. And that way he qualified for youthful offender status. Upon information and belief, Mack and Jackie Butler were aware of Butler's disturbing behavior and did not seek help for their son or take any corrective action. From January of 2024 through March of 2024, for approximately 6 weeks, LS and Jesse Butler were in a dating relationship. So that's when these events occurred, January through March of 2024. Almost 2 years ago. Beginning in February of 2024, Butler committed multiple essays against LS. On one occasion, Butler essayed LS at the Butler's residence. Upon information and belief, Jackie Butler heard LS crying while Jesse Butler was assaulting LS at her home, and she knocked on the door of the room that they were in. Jesse Butler told his mother through a closed door that everything was fine. Upon information and belief, Jackie walked away and Jesse continued assaulting LS. On one occasion in a Walmart parking lot, Jesse Butler forced himself onto LS, put his hands around her throat, and strangled her in a Walmart parking lot. I'm sure they don't like this product placement. A doctor later informed LS that she nearly died when Butler strangled her. LS required surgery to repair the damage that Butler caused to her throat. On or about September 11th of 2024, LS became aware that another girl was a victim of Butler. While discussing Butler's abuse at church with the other victim, a youth worker overheard the girls and informed them that unless the girls reported Butler within 24 hours, the youth worker would be forced to report Butler. Praise be, mandatory reporters doing the Lord's work and trying to protect these young girls. On September 12th of 2024, LS reported to assistant principal Tommy Grant, Tommie Grant, that Butler had essayed, strangled, harassed, stalked, and abused her. Okay, so this was I guess maybe this was the beginning of their senior year. 6 months later, 7 months later. Anybody who knows anything about SA knows that this is not quite a delayed disclosure the way that the district attorney wants you to believe. Many victims / survivors of SA never disclose. Ever. When I sued the Catholic Church for 50 or 60 victims of clergy SA, most of them were in their 40s, 50s, and 60s and had never told a soul. I don't see any difficulty in trying this case, the way the district attorney made it seem. That because she waited, a jury likely wouldn't believe her. Let me know what you think. So the day after the youth worker overheard the girls, LS went to the assistant principal and told him what happened. Grant, the assistant principal, called the school resource officer, Blankenship, to the office, who interviewed LS. SRO Blankenship stated LS would have to get her story straight with Butler's other victim, and that she would have to go to the Seville Center for Child Advocacy to make sure she was telling the truth. I don't know. Do you think that maybe they need some training? Do you think maybe this is why people don't tell? Yeah, you need to go over there so they can make sure that you're telling the truth. Upon information and belief, defendant school district did not perform an investigation into Butler's conduct after her report. Upon information and belief, defendant school district took no action to protect LS from Butler. Upon information and belief, defendant school district did not notify staff and employees about LS's report. On September 13th of 2024, Butler began a coordinated campaign of harassment against LS. Yep, Becky. Becky RN says, get their story straight, blame the victims. Yep, she's not 18 yet. She turns 18 in January. You're correct. So it wasn't. She reported on the 12th, and one day later, Jesse Butler began his coordinated attack. Upon information and belief, Butler called LS and had other students call her on his behalf to pressure LS not to talk to the police about him. On September 20th of 2024, LS was cheerleading at a Stillwater high school football game. Butler took pictures of her from the stands, and then he went down onto the track where she was cheering so that he could harass and intimidate her. Butler was not authorized to be on the track. Despite Butler being visible and obviously where he was not supposed to be, no one from defendant's school district removed Butler from the track. Upon information and belief, Mac and Jackie Butler were aware that Jesse was stalking, harassing, and intimidating LS, but they took no action in response. On September 26 of 2024, Amber Selvey filed for an emergency protective order, EPO, against Butler on behalf of her daughter, LS. The EPO was served on Butler while he was at school. Just wait, it gets worse. After Butler was served with the emergency protective order, Walter Howell called Amber and informed her that Mac Butler was crying. That's Jesse Butler's dad, the athletic director. I'm going to read that again. After Butler was served with the EPO, Walter Howell called Amber and informed her that Mac Butler was crying and taking it really hard when the EPO was served on Jesse at school. Can you imagine? During that phone call, Howell requested that Amber report any problems with Jesse directly to him instead of the Stillwater Police Department. Walter Howell was the principal of the high school. Upon information and belief, in response to Butler being served with the EPO on campus, defendant school district instituted a new policy that EPOs are not authorized to be served on students while they are on the school campus. Robin J. says, this is 100% about preserving his father's career, everything. Java Time says, this is disgusting. And people wonder why Aaron Spencer did what he did. Upon information and belief, the policy of the school district is for all EPOs to be entered into an electronic database so that all teachers and staff would know about the EPO, could help protect the student, and could help enforce the EPO. Yes, well, isn't that also similar to child custody issues when one parent is not allowed to be or have contact with a child that's in the school? They need to have that on file so that that parent can't come to the school and pick up the child and potentially kidnap them. Isn't that just basics? Upon information and belief, the EPO against Butler was not entered into the database that fall. On multiple occasions that fall, Butler stalked and harassed LS at school and at school-sponsored activities. On multiple occasions that fall, Mac Butler harassed LS on campus. Yes, Mac Butler, the father. Mac Butler would stand outside the cheer barn and glare at LS when she went there for games. They have a cheer barn in Oklahoma. On December 9th of 2025, LS's deaf/hard of hearing specialist called Amber because LS was uncharacteristically struggling with her school assignments. When Amber informed the specialist about Butler and the EPO, the specialist had no idea what Amber was talking about. Amber complained to Assistant Principal Grant about the staff not being informed of LS's situation. Grant responded by emailing LS's teachers to give grace on missing work because LS was having, quote, a rough go of it. A rough go of it. Yes, Mad 9622 says, we are lucky this girl didn't self-harm. This is outrageous. On January 14th of 2025, Walter Howell called Amber Selvey regarding Amber's complaints with how the school was handling LS's situation. This might be a typo here. This could be December 9th of 2024. I'm not quite sure. Howell informed Amber that he chose not to enter the EPO into the school's database because he did not want to interfere with Butler's opportunity to receive an education at the school district. I'm going to read that to you again. The principal of the school called this girl's mother to tell her that he chose not to enter the restraining order into the school's database because he didn't want to interfere with Jesse Butler's opportunity to receive an education at the high school. During that call, Howell told Amber that he was keeping LS safe by personally keeping Mac and Jesse Butler away from LS. Howell also told Amber that when the EPO is dropped, the school would still keep Butler and LS out of the same classes. I'm sorry, did they expect the parents of this girl to drop the protective order? We'll still keep them out of the same classes, don't worry. Howell's actions demonstrate an utter disregard by defendant school district for implementing and following proper procedures under Title IX. Defendant school district's only concern was to protect Butler without any regard for his victims. On January 22nd, 2025, school resource officer Blankenship pulled LS out of class for a private meeting, which is against school policy. At the meeting, the school resource officer informed LS that he was aware of Butler's habit of stalking LS in the school parking lot. School resource officer Blankenship informed LS that as long as Butler did not speak to her, SRO Blankenship would not do anything about Butler's conduct. I mean, can you even? My head has popped off and it's on the way to Connecticut. Matt says, I'm a teacher. Yes, I need to know. And it's always in the computer in big red letters and exclamation points. We need to know to protect the child. These administrators are outrageous. Becky B says the SRO and Butler's dad are pals. Could have guessed. I could have guessed that. Yeah, they are suing him as well. He's a defendant in this lawsuit. Upon information and belief, SRO Blankenship deliberately pulled LS out of class and then escorted her back to class to embarrass her. Upon information and belief, on January 28th of 2025, Mac Butler, Walter Howell, and SRO Blankenship attended a school wrestling match as part of their job duties. LS was required to be at the wrestling match for cheer. The three men sat together and glared and intimidated LS during the match. Are you surprised? Tara Christine, no, there was no female president during that meeting. It was a private meeting between just him and her. Tara Christine says, please tell me there was a female present during the meeting with a male SRO. Being alone could be triggering after what she went through and very intimidating. No, they didn't. And BB says, so he can stalk her and harass her in the parking lot as long as he doesn't say words to her, right? And apparently get as close to her as he wants because they don't say anything about a restriction of staying 100 yards away or however far away he probably had to stand or stay away based on that stay away order. On January 29th of 2025, school district held its first safety plan meeting for LS. The meeting was a locked door meeting with only the individuals on the safety team were supposed to be in attendance. The meeting was held in Walter Howell's office. Again, he's the principal. Remember, this is January. 4 months after the school was notified about the restraining order. 4 months later. During the safety plan meeting, Walter Howell came into the room and stayed where he could overhear the discussion. Guess he was not part of the safety team. Howell then left the door open, which was adjacent to the front office, so that the meeting could be overheard by individuals in the front office. Thank you, El Hutch, because I was going to say this too. And by the way, what mother allows her teenage son to be in his bedroom with a girl at all, let alone with the door closed? Thank you for saying the quiet part out loud. I thought I was just a little old-fashioned, maybe. Oh, please. Upon information and belief, SRO Blankenship, Howell, and other parents and staff could overhear the meeting. The only actions taken at that safety meeting to protect LS were 1, to move Butler's parking spot across the parking lot, and 2, to allow LS to leave third period early to attend cheer. Upon information and belief, school teachers and staff were not informed of LS's safety plan. Upon information and belief, SRO Blankenship was required to attend LS's safety meeting as part of his duties as a school resource officer, but he did not attend the meeting. Why would he? He just does whatever he wants. On January 30th of 2025, Tyler and Amber Selvey complained about the SRO Blankenship's conduct to his supervisor, Lieutenant Cluck, at the Stillwater Police Department. So the school resource officer is technically employed by the police department. He's law enforcement. After listening to the Selvies' complaints, Lieutenant Cluck told the Selvies that SRO Blankenship is friends with the Butlers, so they should not hold SRO Blankenship's conduct against him. I'm sorry, what? Did you hear that part? I'll read it again.
Hello.
Hello. Hello, I'm here.
Sometimes we need Cardi B. Paragraph 71 reads, and I will read it again. After listening to the Selvies' complaints, Lieutenant Cluck told the Selvies that SRO Blankenship is friends with the Butlers, so they should not hold SRO Blankenship's conduct against him. Don't hold it against him. They're buddies. No big whoop. I mean, your daughter's probably going to graduate soon, so, who cares? Who cares if she fails out senior year because of her PTSD? And I don't know what her grades were, actually. And, it is afraid to come to school every morning because this kid is stalking her and his father is stalking her and they're not protecting her. Can you imagine the pit in her stomach? It makes me want to cry. How this girl probably felt getting up to have to go to school every single day. That makes me want to cry. And this kid gets a pass because what? They wanted to make sure he got a scholarship for baseball. Did he play football too or just baseball? I don't know. He almost died. Upon information and belief, nothing was done regarding SRO Blankenship's conduct after this meeting. Why would it be? Upon information and belief, the school held a safety meeting for Butler approximately 1 week after LS's safety meeting. Oh, a safety meeting for Butler? The kid? Upon information and belief, the school held this meeting because it believed that Title IX required them to treat Butler equally to LS. Just baseball, Cindy? Upon information and belief, Butler's safe people were designated as MACK Butler, Walter Howell, and SRO Blankenship. Well, isn't that interesting? Jesse Butler's safe people were his dad, the assistant athletic director, the principal, and the school resource officer. I was just thinking the same thing, Amanda. This is just like Lonoke County, Arkansas, isn't it? He is not a victim. Thank you, Barbara. Thank you. You're full of questions, and that's a statement, not a question. And Pierce says, this makes me want to homeschool my daughter even more. I'm just saying, says he needed a threat assessment, not a safety team meeting. Shine on you, crazy diamond, says, as I said, most schools only care about their reputation, even without any personal involvement. They don't care about the human aspect at all. I don't know if all schools are like that. It's a generalization, but I hear what you're saying. On February 5th of 2025, Butler violated the girls' restraining order. Student athletes were on the basketball court for a school-sponsored event, Senior Signing Day. SRO Blankenship was in attendance, as were multiple members of the administration, and staff were present. At Senior Signing Day, in full view of staff and administrators, Butler came within 5 feet of LS to stare at, harass, and intimidate her. I don't have a copy of the restraining order, but if anybody does, could you please email it to me? Not one school employee intervened on LS's behalf in response to Butler's violation of the EPO. It was only when one of LS's cheer teammates informed a cheer coach about Butler's conduct that anyone intervened. The cheer coach removed LS, not Butler, from the course. From the court. I'm sorry, the court, not the course. The only action the school took to support LS after the EPO violation was informing her that if LS wanted to attend an activity and she informed the school ahead of time, Butler would not be allowed to attend that activity. Upon information and belief on February 10th of 2025, the school had a second safety plan meeting with Jesse Butler and his family. Upon information and belief, MACK, Butler, Walter Howell, and SRO Blankenship advocated for Butler not to have any consequences from the school for violating the EPO. My head is bouncing through Connecticut, and I think it's going to go up through Massachusetts and possibly New Hampshire and Maine. If anybody wants to catch my head, that has popped off and is on the way. That was February 5th, Senior Signing Day. By February 10th, they had 5 days later, they had a meeting with Jesse Butler and his family, and his dad, the assistant athletic director, and the principal and the school resource officer were all Team Jesse. Team Jesse. After Jesse Butler's safety meeting, the school asked LS not to attend any baseball games or related events because it would interfere with his ability to participate in the baseball team. Samantha Layton lives in central Oklahoma, and this is really pissing her off too. LS was generally discouraged from participating in school activities so that she would not interfere with MACK and Jesse Butler's ability to attend activities. So she's told she can't come to any baseball games. And by the way, why don't you just not come to anything? Because, we don't want to interfere with Jesse Butler and his dad's ability to go to activities. There is another known victim There were criminal charges brought both for LS and the other known victim. I'm suggesting to you that there may be more that will never come forward after this. But I would encourage them to please do so that maybe this guy can be locked up where he belongs. Because there's no question that he did these things. This is not an innocent until proven guilty situation. He taped it on his phone. On March 4th of 2025, Butler was arrested and charged with 9 felony counts, 7 of which were for his SA, assault, battery, and harassment of LS. So he was arrested. That's the body cam footage that we saw, and that goes all the way back to March. This didn't even get onto our radar until, I don't know, a month ago, maybe 2. Time drifts, time drifts. Nine felonies, 7 for LS. Butler pled no contest. So he pled no contest to the criminal charges, not guilty, but basically the same thing. Just didn't want to admit that he was guilty, but Butler pled no contest to the criminal charges and was sentenced as a youthful offender to community service. After Butler was sentenced, members of the Stillwater community went out to protest the light sentence he received. Upon information and belief, defendant school district instituted policies to prevent students from protesting Butler's sentencing. The fact that this kid was not expelled from this school tells you everything that you need to know. Upon information and belief, defendant school district scheduled mandatory activities for seniors on the day the protests were set to occur, and by instituting a policy that penalized students for attending protests during the school day. So these students at Stillwater High were silenced, threatened, told that they were not allowed to stand up for what they believe in. On July 3rd of 2025, LS had surgery to repair damage to her neck caused by Butler strangling her. On August 4th, 2025, defendant school district finally informed LS that Butler would not be allowed on campus for any reason. I mean, isn't that great? It's summertime. During the fall semester of 2025, Walter Howell, he's the principal, in case you forgot, continues to attend football games where LS is cheering, and he repeatedly stares at and harasses LS and her family. So the principal of this school is continuing to harass this girl. Damages. Plaintiff LS required surgery to repair her injuries from Butler strangling her. Plaintiff LS is still receiving medical treatment as a result of her injuries from Butler. Plaintiff LS has suffered and continues to suffer severe mental and emotional anguish. Plaintiff LS experienced harassment from Jesse Butler, MACK Butler, Walter Howell, and SRO Blankenship. Plaintiff LS continues to experience ongoing harassment from Walter Howell. Plaintiff LS has received and continues to receive counseling for the mental and emotional anguish caused by defendant's actions. Plaintiff LS's ability to receive an education was and continues to be impaired. I'm sorry. Read that again. Plaintiff LS's ability to receive an education was and continues to be impaired. Plaintiff LS's ability to participate in extracurricular and other school activities was impeded and continues to be impeded. Plaintiff LS missed time from her job as a cheer and tumbling coach as a result of defendant's actions. Plaintiff LS is entitled to the following damages as applicable under federal and Oklahoma law. A, physical pain and suffering, past and future. B, mental pain and suffering, past and future. C, loss of educational opportunities. D, loss of ability to participate in extracurricular activities, loss of earnings, loss of enjoyment of life, impairment of earning capacity, loss of reputation, the reasonable expenses of the necessary medical care, treatment and services, past and future, attorney's fees, compensatory damages, and interest accrued and accruing. Right. A no contest is a plea. A no contest plea is essentially saying, I'm not going to admit that I'm guilty, but I'm going to admit that there's enough evidence that a jury could find me guilty. Thank you, Amethyst. Plaintiff LS is entitled to punitive exemplary damages as applicable under federal and Oklahoma law. Plaintiffs Tyler and Amber Selvey have incurred and will continue to incur medical expenses for LS's treatment as a result of defendant's actions. Due to the damages detailed above, LS was unable to fully participate in the family or perform her usual chores. Tyler and Amber Selvey had to perform additional household work to compensate for the loss of LS's services, and plaintiffs Tyler and Amber Selvey are entitled to compensatory damages for the loss of services. First claim for relief is a violation of Title IX on behalf of the plaintiff, LS, against the defendant, school district. And here's Title IX. Here's what it states. In part, no person shall, on the basis of sex, be excluded from participation in, be denied the benefit of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. And that is found in 28 U.S. Code 1681A. That is Title IX. Part of it, anyway. The school district is an educational institution that receives federal financial assistance, and therefore they are obligated to comply with the terms and provisions of Title IX. Defendant school district has a recent history of failing to protect students from sexual predators. See Payne County Court number. Payne County Court case number CF2152, State v. Morajon. Oh, well, I'm going to have to look into that one. Anybody knows what that case is about? Let me know. Defendant school district created a hostile educational environment by failing to protect LS from Butler. Defendant school district had actual knowledge of Butler's harassment and abuse. Instead of reporting Butler's conduct to teachers and implementing a safety plan, the school allowed Butler and employees of defendant school district to harass and intimidate LS on campus and at school events without intervening on her behalf. Is it the other victim? I'm not sure if it's the other victim in this case. I'm not sure if it's a case that happened years before this. I just don't know. The judge decided it's a good time to retire. She's out the door. Is that true? Defendant school district's employees who had actual knowledge of the abuse and harassment had the authority to take corrective action to end the unlawful conduct and did not do so. Instead, defendant school district's employees who had the authority to help LS used their authority to shield Butler from consequences and retaliate against LS. This is repulsive. Defendant school district had created a hostile educational environment and retaliated against LS by failing to investigate Butler's conduct, failing to stop Butler from harassing and intimidating LS on multiple occasions, failing to notify its employees regarding LS's emergency protective order after it was entered against Butler, How many of you work in the school system and are outraged by this? That you would not be notified of this restraining order on behalf of one of your students. Failing to enter LS's EPO into the school's electronic database so that teachers and administrators would receive notice. They just hid it. They just hid it. Swept it under the rug. Delaying the implementation of a safety plan for 4 months after the service of the EPO. Refusing to enforce LS's EPO after Butler stalked and harassed her on campus. Allowing Butler to violate the EPO of LS in full view of teachers and administrators. Allowing its employees to engage in a pattern of harassment and intimidation on school property. Interfering with LS's safety plan meeting. Taking inadequate action to protect LS even after the implementation of the safety plan. Discouraging LS from participating in and attending school activities so that Butler and his father could continue participating in them. Implementing a safety plan to protect Butler's access to his extracurricular activities. Banning LS from attending baseball games to protect Butler's access to his sport. Implementing policies to prevent students from being served with protective orders on campus. Implementing policies to prevent students from protesting Butler's sentencing. They didn't want this victim to have any support at all from her students, her fellow students, classmates, and friends. The abuse, harassment, and discrimination suffered by LS was so severe, pervasive, and objectively offensive that it deprived her of access to the educational benefits and opportunities provided by the school. LS is entitled to compensatory, special, and punitive damages as detailed herein as a result of defendant's school district's Title IX violation. LS's damages are in excess of $75,000, exclusive of costs and interest. LS is entitled to an award of punitive damages as a result of defendant's school district's Title IX violations. That doesn't mean she's only suing for $75,000. It means that she is suing for $75,000 or more, and those are the jurisdictional limits of the court. And in order to get into federal court, you have to allege that your damages exceed $75,000. Second claim for relief is a violation of equal protection under 42 USC on behalf of the plaintiff and against the school district, based on the fact that after LS reported Butler's SA and harassment, defending school district acted with deliberate indifference to her rights, a civil rights violation, as are all of these. And in my opinion, she's got a very strong case. Well, her parents do right now because she's not 18 yet. When she's 18, which is coming up next month, she can be substituted in as the plaintiff. Defendant school district allowed a hostile environment to exist after her report. Instead of protecting the victim and ensuring her safety, the school district took actions and implemented policies to protect Butler at her expense. The school district allowed its employees to engage in a pattern of harassment and intimidation against LS. LS is entitled to compensatory, special, and punitive damages as detailed herein as a result of defendant school district's equal protection violations. Again, damages are in excess of $75,000, and she believes she's entitled to an award of punitive damages. Third claim for relief is intentional infliction of emotional distress on behalf of the plaintiff LS against defendants Jesse Butler, Mac Butler, Walter Howell, and Paul Blankenship. Defendants' actions in the setting in which they occurred were so extreme and outrageous as to go beyond all possible bounds of decency and would be considered atrocious and utterly intolerable in a civilized society. Defendants intentionally or recklessly caused severe emotional distress to LS beyond that which a reasonable person could be expected to endure. LS is entitled to compensatory, special, punitive damages, and her damages are in excess of $75,000. Intentional infliction of emotional distress is a common law claim, a tort claim, whereas the first two that we read violation of equal protection, and Title IX are civil rights claims. Fourth claim, respondeat superior on behalf of plaintiff LS against defendant school district and city. The doctrine of respondeat superior states that an employer can be held responsible for the actions of its employees under certain situations rooted in the common law. That is also a tort claim. Defendants MACK, Butler, Walter Howell, and Paul Blankenship were acting within the scope of their employment when they intentionally inflicted emotional distress on LS. Defendants school district and city are directly liable for the actions of their employees while in the scope of their employment. Eighth claim for relief, negligent hiring, supervision, and retention, and gross negligence. Again, these are tort claims rooted in common law that stand for the premise that an employer has a duty to vet their employees, to supervise their employees. And if they find out that their employees are violating harming people under their control, that the plaintiff is entitled to recover for those damages. And gross negligence on behalf of LS against defendants, school district, and city. Defendant school district and defendant city had a duty to LS to hire, supervise, and train MACK, Butler, Walter Howell, and Blankenship, the school resource officer. Defendants negligently breached their duties to LS by hiring, failing to supervise, and or retaining MACK, Butler, Walter Howell, and SRO Blankenship by allowing defendants to harass, embarrass, and intimidate LS in the course of performing their work. Defendants' failure in hiring, supervising, and retaining MACK, Butler, Walter Howell, and Paul Blankenship was the direct and proximate cause of injuries to LS. LS is entitled to compensatory and special damages as detailed herein as a result of defendant's negligence. The damages are over 75 grand. And defendant school district and city acted with deliberate disregard of LS's rights in their hiring, training, and supervision of MACK, Butler, Walter Howell, and Paul Blankenship, that they were grossly negligent and punitive damages should be awarded against them. Walter Howell is still employed as the principal of Stillwater High School. Let me give you a very short and brief lesson in negligence and negligence causes of action. Think of a negligence tort claim as a four-legged stool. And you need all four legs, and you need to prove all four legs in order to prove a claim for negligence. Here's the legs of the stool: duty, breach, causation, damages. You have to show that the defendant owed a duty to the plaintiff. That's exactly what they're doing in the first paragraph. Defendant school district, 137. Defendant school district and the city had a duty to LS to hire, supervise, and train MACK, Butler, Walter Howell, and SRO Blankenship. You have to show that there's a duty between the defendants and the plaintiff. Then you have to show how that duty was breached. This is the next paragraph. Defendants negligently breached their duties by hiring, failure to supervise, and failure to retain MACK, Butler, Walter Howell, and Blankenship by allowing them to harass, embarrass, and intimidate her in the course of performing their work while they were in the scope of their employment. Next, you have to show that the breach of that duty is what caused the injury or the damage to the plaintiff, which they allege in the next paragraph. That defendant's failure in hiring, supervising, and retaining MACK, Butler, Walter Howell, and Paul Blankenship was the direct and proximate cause of injuries to LS. And then you have to show that the plaintiff actually was injured and sustained injury. As they allege here. Duty, breach, causation, damages. I think his sport is baseball. Back to the complaint. Negligence on behalf of plaintiff LS against defendants MACK and Jackie Butler. Upon information and belief, MACK and Jackie Butler were aware of Butler essaying LS and could have prevented it. Upon information and belief, Jackie Butler overheard Butler essaying LS and negligently did not intervene. MACK and Jackie Butler's negligence was the direct and proximate cause of LS's injuries. LS is entitled to compensatory damages and special damages as detailed herein as a result of defendant's negligence. Seventh, claim for relief is battery on behalf of plaintiff LS against Jesse Butler. Defendant Jesse Butler, without the consent of plaintiff LS, acted with the intent to make harmful contact when he essayed LS and strangled her as described above. LS is entitled to compensatory, special, and punitive damages as detailed herein as a result of Jesse's battery. Eighth claim is assault on behalf of plaintiff LS against Jesse Butler. Jesse Butler acted with the intent of placing LS in apprehension of harmful contact when he stalked, intimidated, and harassed her on multiple occasions as described herein. Plaintiff LS was placed in apprehension of immediate harmful contact as a result of Butler's conduct and suffered fright and terror. Therefore, she's entitled to damages, special, compensatory, punitive, as described herein, as a result of Jesse Butler's assault. Ninth claim for relief is negligence on behalf of LS's parents against all defendants. And this is what you call a loss of services claim. And to people who don't do negligence complaints or negligence work as a job, it might seem odd to you. But rooted in the common law is this theory that spouses are entitled to services from each other. In the case of spouses, it's often intimate services. And services also from their children. And it sounds like archaic language, and that is because it is. Plaintiffs Amber and Tyler Selvey are the parents of LS. As such, plaintiffs are entitled to the comfort, enjoyment, and society of their child. As a result of a direct and proximate result of the foregoing, her parents were deprived of the comfort, enjoyment, and society of LS. Plaintiffs are entitled to their consequential damages for LS's medical expenses and the loss of services as identified above. Wherefore, plaintiffs Amber Selvey, Tyler Selvey, and LS respectfully request an award of damages in excess of $75,000, punitive and exemplary damages, interest accrued and accruing, attorney's fees and costs incurred, together with any other legal and equitable relief as proper and just. XOXO, Moore Schreier Law Firm, Pansy Moore, her name is Pansy Moore Schreier, and I love this. I love that name, Pansy Moore. I looked her up the other day. Let me look her up again for you. She looks like a power woman coming out to represent a victim of horrific injustice by not just Jesse Butler, his parents, and the school district and the city, but the athletic director, assistant athletic director of Stillwater High, who happens to be Jesse Butler's father, and the principal and the school resource officer. This was just filed 12/22/25, a couple of days before Christmas. So Merry Christmas to you, Jesse Butler and family. Why does Butler still have a job? Good question. Good question. With that, I can't answer. But let's take a look at the biography of Pansy Moore Schreier. And here she is. Here's her bio. They're located in Tulsa. And it is a very, very small font on the bio. So let me just read it to you while I enlarge it for myself. Pansy Moore Schreier was born in Tulsa, Oklahoma. She received her Bachelor of Science in Psychology from St. Mary of the Woods. She returned to Tulsa, Oklahoma to attend the University of Tulsa College of Law and received her JD with honors in 2004. Ms. Moore Schreier maintains a general litigation practice in Oklahoma and has been involved in complex matters throughout the United States. Ms. Moore Schreier has a broad range of practice areas, including insurance coverage, insurance defense, bad faith litigation, commercial litigation, and family law. Praise be for lawyers like Pansy Moore Schreier standing up for victims' rights, because this is what I did for my 30-plus year career. Let's go to the chat, because if you're anything like me, you're incredibly outraged. I think they have a very strong civil case, and we'll see where this goes. We'll see where the motion goes also, to see if the court reconsiders its position. But based on that statement from the district attorney that we read earlier, who's also a female, my hopes are not very high. Thank you, Chris Flynn, for becoming a member. Thank you to Terry Sue for being here for 4 months. And she says, I love it here. Thanks, Melanie. Thank you. Cherie is here. She's been here for 14 months. Merry Christmas to you and to all the cupcakes. And Happy New Year to you, Cherie. And thanks for being here for 14 months. Happy New Year to Amanda. Been here for 10 months. You're amazing. On top, thank you for your super sticker. Elizabeth says, so despicable. I'm a DV survivor. I pressed after multiple incidents, including being strangled. All he got was anger management on Zoom 1 time a week for 2 months. I'm so sorry that happened to you. It's not your fault. And the system sucks in many places, and it needs to be fixed. Thanks, Elizabeth. Kim Farnham became a member. Thanks, Kim. I think you've been here for a long time, though. UK Anton, did the parents contribute to the DA's coffers? Don't know, but it's worth looking into. Thanks for tuning in from across the pond. Mason 2991 says Cardi B was recently seen at a Nordstrom in my area and took photos with fans. Stefan Diggs is from here. Yes. I was wishing I was there that day to tell her she's our emotional support. Oh, thanks, Mason. That would have been really cool to meet Cardi B. She does a lot of meet and greets, actually. She was here on Long Island, and I think a lot of people went to it and got pictures of it. Thanks for your 20. Ginger Mom Bear says, if that was my daughter, that protected kid would not get away with it. Vigilante justice. Well, that's why people are, supporting Aaron Spencer, who did take the life of Michael Fossler after he kidnapped his daughter, after he was charged with 43 felonies with regard to the essay of his daughter and let out on $5,000 bail. Aaron Spencer's trial is scheduled to start January 26th, and the same judge who let Michael Fossler out on bail will be overseeing the trial of that case. Yes, because you just can't make it up. That's in Arkansas. Thank you, Ginger. Mama, although I cannot in any way support or encourage vigilante justice, I never would do that. I'm just saying juries sometimes nullify. Jury nullification is a thing. It is a thing. Ms. Black says, OM ducking God. I'm 15 minutes behind. All I see is a plot straight out of 13 Reasons Why Netflix show. Thank you for your tuning in. Thank you for tuning in. And for your super chat. Karen Griswold says, my daughter's bestie was raped by a teacher, $2.1 million verdict. Good. Not good that it happened to her. Good that she was able to get a large verdict or settlement, whatever that was. I don't know where it was, but I will say that no amount of money can undo what has happened to this girl. No amount. They can't write a check big enough. No amount of money can undo what happened. Ms. Bouquet says, I'm honored to have been a member for 20 months. Thank you. Thank you, Ms. Bouquet. Thanks for tuning in. Merry Christmas. Happy New Year. Robin says, since it is in excess of 75, does that mean federal? Yes, that is a federal lawsuit. If you tuned in late, that was filed in federal court just this past week on the 22nd of December. Civil rights violations often are filed in civil court, and it is a good venue to be in. I'm not sure what it's like in Oklahoma, but you can tell me. Scooter, outstanding content in every aspect, says Scooter 5480. Thanks for being with me for 14 months. And I appreciate you so much. Thank you, Proctor God Waffle, for gifting a membership. You're amazing. I appreciate you so much. All of this is terrifying, just on every level. It's all terrifying. Oh, please. Thank you, thank you, thank you, thank you. I did not have these documents because I didn't look for them yet, so thank you. Zeta 4 for sending this to me. The motion, it's 24 pages though. I don't have time to read it right now because we're coming back to do a story. We're going to start our deep dive into the Sarah Grace Patrick case at 12:30, and I have some things at 2, and I have some things I need to do before that, but we will go over these documents on another stream. So thank you so very much. It is the motion filed by one of the victims. And it looks like there's going to be a preliminary conference February 3rd with regard to this motion. And it's a victim named KS who filed. So it must be the other victim who filed this motion to enforce the victim's constitutional rights under Marcy's law. So now that we have these papers, we can go over them in greater detail. Thank you so very much for sending this to me. Thoughts, questions, comments, concerns. The trial for Sarah Grace Patrick is supposed to start next Monday, which is why I want to get into it today and the court filings that I have. And we will do that. So let me see. Let me just make sure I have the redirect set up. I mean, will there be justice for LS and for the other victim? How do we make sure that happens? We have to be out. We're outraged by this, and we need to do something about it. I just don't know exactly what we should do yet. But what you can do is, if you are in any Facebook groups for against the Jesse Mack Butler situation, what you can do is share this stream in that Facebook group. That would be very helpful, so that more people can find us, so that more people can know that we're outraged by this, and to find out how we can help these poor girls get justice. Actually, a shine on you, Crazy Diamond. It's not surprising to me at all that there are so many survivors in the chat, because these are the cases that we cover. And so many of you are willing to share your stories with each other and talk about things that have happened to you. And I'm so, so sorry that these things happen to you. It doesn't surprise me at all. It's horrifying. Proctor Got Waffled says, you're my second most watched channel in 2025. Oh, thank you. Thank you for being here for 8 months. And thank you for having me as your second watch channel. I think they're doing YouTube wrap-ups. I think that's what I heard. Happy Christmas and Merry Christmas and Happy New Year to you too, Jessica. Thanks for hanging out with me for 9 months. So yeah, if there are any Facebook groups about Jesse Butler and these poor girls and what happened to them, I'm going to brainstorm some ways that we can try and help, because I am outraged. I am outraged. Our daughters deserve better than this. These things were rampant in the 80s, 90s, for decades. People were afraid to stand up, and people were afraid to speak out, and people were afraid to report because of what would happen to them if they did, and how they wouldn't be taken seriously or believed. And it's still going on. And this is horrific, and you should be horrified. Thank you. Columbo Wannabe says, I was your first most watched channel. Thank you so much. Let's see. All right. Buckle your seatbelts because when I end this stream, I am going to. Yes, he did plead no contest. Yes, we did plead. We went over that. Thank you. He did. He didn't take accountability, but he admitted that they had enough evidence to convict him. And so that is the deal. Okay. All right. Buckle your seatbelts. It's going to be a bumpy ride. Probably not. But I'm going to teleport you over to the 2 p.m. stream. We're going to talk about or start getting into in greater detail Sarah Grace Patrick's case out of Georgia. She is a 17-year-old who is accused of taking the lives of her mother and stepfather. She has a lot of family support. I don't know what evidence they have, but we're going to start digging into the court file to try and find out. So thank you to the moderators for keeping it classy today to the best of your abilities. And stay cool, stay kind, stay classy, and also stay safe out there because it really is a jungle. And I know you guys can do it. I know you can. All right. I'm going to see you at 2 o'clock. So go have a snack, hydrate, and hopefully you'll be teleported right over as I end the stream. Peace, you guys.